I got to tell you, look, we don't know what all the evidence is. We don't know where this is going in court, not court, whatever. We don't know. No one knows. What I do know is the optics of what I'm seeing, and you mentioned it in passing. I asked Ben to pull a couple clips of it. Now, for the audio listeners, you're screwed. Sorry, watch this on YouTube. But you can hear, but you can't see. The facial expressions, first of all, we could have done a 37-minute tape of them making ridiculous faces.
Right.
We had to cut it down because no one wants 37 minutes of them watching ridiculous faces. But, Ben, if you can play that clip just to get a small sampling of Jennifer and James Crumbley acting totally a fool during this hearing.
Her husband instead. When she was informed that they tried to call her husband, but when he picked up, they only heard dead air. What's been admitted is Exhibit 1 and 2. And they're told that immediate therapy is needed. Immediate as in that day. They resisted, instead asserting that they couldn't possibly take him out of school because of work. As you've heard Prosecutor McDonald state, Judge, drawn by Ethan, bore a striking resemblance to the gun they bought for him 4 days before.
So for those that weren't watching, they're shaking their heads, rolling their eyes, smiling, mouthing things, making a mockery of this thing. Now, jump in if I'm wrong. My understanding in the era of COVID is that there's no distinction. That Zoom is the courtroom in terms of etiquette and decorum. Is that correct? That's considered you're in the courtrum.
Of course. Oh, you're asking what Zoom technology? Yes.
Yeah.
Yes.
So
there's
no
you're
distinction.
considered to be in a courtroom,
right?
As if you're at table,
right? So don't get away from there's Zoom sitting in another room somewhere.
Right.
In the eyes of the system,
and they're looking at the courtroom. The judge is in the courtroom.
The judge is in the courtroom. But there's just don't let that is no different from them sitting at the desk in the courtroom itself and giggling and making ridiculous faces. Right. Look, the Crumbleys, I think, are profound pieces of shit. I think that's obvious. I don't care what anybody says. The attorneys, I don't know them, but either they didn't counsel their clients or they did, and their clients are even dumber than we thought. Because how are you're a defense attorney. I'll throw it into your lap. If you have a client in this situation, or any situation, you're on trial or at a hearing, maybe to go to trial, do you not sit them down and say, poker face, don't react, don't roll your eyes? Isn't that a discussion at some point? Because apparently it didn't happen or didn't sink in if it did, because I don't know what's going on here.
Yeah, the answer is yes. Let me put my attorney qualifiers on the beginning of the statement. I know Shannon and I know Marielle, and even if I am critical of them, I think they are extremely talented lawyers. They have had some tremendous successes. They had a federal case dismissed in a federal female genital mutilation case where a Muslim doctor was accused of FGM, and that was on constitutional grounds and others. They got it dismissed. They are talented lawyers. So I am, 1,000 feet removed from this case. I'm not in it. I don't know some of the things that they know. I'm not having the conversation. So if anything is viewed as criticism, it's not on necessarily their skill. It's just, how I view it, and to benefit your audience, my thoughts on it. So I did want to say that they are very skilled attorneys, and I've worked with them, and I know them to be good at their craft. As far as your question as to preparing clients for that, I would. Sometimes clients don't listen. I've certainly had it happen to me. What I prefer and often do in that situation, I'll actually stop the proceeding and admonish my client. I think there's credibility in that because you can share why you're doing it. Mr. Crumbley, stop, or so-and-so.
Like in front of everybody.
Oh, yeah, stop. I know you're upset. We'll talk about it, but just let them finish or let them do this. And you're kind of acknowledging it as opposed to letting it go on, and it maybe puts some human element on it, because these things can be frustrating. I've heard prosecutors take liberties with the truth before. I'm not saying that happened here. Again, great prosecutors and no reason to believe that this is anything but the truth. But I've had other prosecutors who I don't have as much esteem for that have played loose and fast with some facts, and that frustrates my clients, and they'll shake their head or they'll say no. And if I'm physically with them, it'll be an elbow or a stop it. If I'm not, if it's on Zoom, sometimes I think it is worthwhile piping up and stopping it, because then you can try to contextualize it. Like, I know we disagree, so-and-so, but it's just, we'll talk about it after. So, yeah, I think there should have been counseling before. Perhaps stop it there, because it's a bad look. And again, your credibility is everything. You're at a bond hearing asking for a reduction in bond, and this is how you're carrying yourself. I mean, how can the court be expected to have their, when you're deciding a bond, you're deciding whether or not someone's going to show up to court and whether they're dangerous. I mean, if you can't control yourself and, have some maturity during the hearing, it doesn't really inspire confidence in you that this was just a one-off, fleeing situation.
It speaks to the character, and
it's hurting their credibility going forward at each level here.
You're looking like the person that is doing everything they're saying that you did.
Right.
You are not taking this seriously. This is not a case of somebody stealing somebody's golf clubs.
Right.
This is a hearing about the worst school shooting in the state of Michigan's history, I believe, right? This is 4 kids getting gunned down, 7 kids wounded, some very badly. This is not a petty theft hearing. That even if you disagree, and look, we're all human.
That's a great point.
We're all human. I would even give them, if they thought something was outlandish, I'd give them a weird face. You can't go on there for 26 consecutive minutes making a face every 4 seconds. That's not, they're human, we're all human, we have human reactions, and then we bring it back in. This was they didn't give a fuck. They didn't care at all. It was, if you watch,
they're making themselves the aggrieved.
Yeah,
in this.
That's what I'm saying. Am I bothering you, Crumbley?
Right.
I'm sorry. Am I putting you out by having you at this hearing now? Even if I think you're not guilty of the charges the statute reads, particularly the second element of causality, I'm sorry. You're a piece of shit that's here and caused this, if not in a legal sense, a moral sense. And like I said, a D+ set of parents doesn't have this result. So the flippancy. I know them. I don't know how well you know them. If you had to guess, do you think they probably told them not to do that because they do a shit job of listening?
I think it's the latter. Would be very surprised if Shannon and Marielle, as talented and experienced as they are, didn't counsel them on that. But I think you're getting a glimpse into probably who they are, right? Not they being the lawyers, they being the Crumbleys, because I don't think they listen. And look. Let me acknowledge what a lot of my clients, go through in different situations, and I certainly think I've defended a lot of innocent people. They're incarcerated. They basically have no bond. You order $500,000 for someone with no money, it's basically saying no bond. That's hard, and you're cut off from the world and the news, and don't know necessarily everything that we know or how people feel about them. So. The best spin I can put on it to have at least some thought about why other people might do this in this situation, them I have a little less sympathy for because of the circumstances and everything that has led up to this. But you can understand why a lot of people get frustrated being incarcerated, being denied a bond. They're hearing things that they disagree with. It's not uncommon, is what I'm saying. In this case, given the chain of events, gotta lock it down and gotta put your best face on it. You're asking for something here that's very important, which is a bond, or an accomplishable bond. I think they asked for $100,000, which would be $10,000 to a bondsman. If people don't know how bail bonds work, you pay them a 10% fee to post your bond if you don't have it. And that's a big difference, being out on bond rather than incarcerated before your trial. You can go to your attorney's office often to prepare. You have access to things, and investigators, your experts, the discovery, your attorney's office, just your own bed. I mean, the obvious too. But in preparing for your trial, huge difference for the attorneys and the defendants in being out versus in. So I understand the frustration. If you're, someone trying to understand how this all works, we can understand the frustration. That's probably where it came from. But I'm sure Shannon and Marielle counseled them. They're just not listening and going to need a little sharper words probably to understand. This ain't getting you anywhere.
Well, anyway. In this case, this matters because
exactly
you said
this case in particular.
Exactly. I said 50-50, and I stand by that as a layman with who did go to school for this stuff but doesn't work in it. You're accomplished. I know you don't want to give me the percentage, but what you did say was you didn't say, I don't know. The defense has a great argument here. And you didn't say it's a slam dunk the other way either. You agree there's, to whatever extent, some murkiness there. When there's murkiness about the statute, about the elements of the statute, the crime that's been alleged.
Not elements about the statute, the murkiness as to whether or not a jury is going to find it's met. We know.
Well, that's what I mean.
Very clear law.
I'm not talking about the law on the book being murky. Gotcha. I'm talking about the facts. Do they align or not being murky? when it comes to a situation like that, which we both agree they are, neither one of us thinks it's a slam dunk, whether you're 60-40 and I'm 50-50. We both agree it's closer to the middle than one way or the other. The credibility starts to really matter, and you have to navigate that murkiness a little bit better than they are. This has been a catastrophe.
Absolutely
It's
right.
been a total catastrophe, and I don't think these attorneys, I'm sure they did talk to him. I don't think the defense counsel lied when they went in front of the media and said, oh, they're turning themselves in. I'm sure that is what they told their clients to do. I'm sure the clients said, okay, and then just didn't listen. That's the Occam's razor explanation.
I would really love to know how they can make that representation that they were still going to turn themselves in.
They are.
I'm really would love. There's something that we don't know because they're too smart and too talented to be making that representation if they don't know something we don't. It just, but the optics are bad. I just like I gave you the example of, can be an alternative explanation and panic.
Yeah,
and that's okay.
The civil trials in Columbine of the parents, the wrongful deaths, they were not charged criminally. The civil trials, they were sued. I mean, the Klebold's, I don't know about the Harrises, the Klebold's were sued like 76 times or something crazy. It was a ton of them. Sue Klebold's book is just heartbreaking, but talks about it in detail. But their approach, they defended themselves. They didn't just say, here's a check. Like they thought that, and they really didn't know. Again, no evidence that they knew anything. But their whole approach was not defiant. We didn't know shit. Eye rolling. Anytime Sue and her counsel would speak in front of the media, it was contrition. This is a horrible situation, but guys, we didn't have anything to do with it. We didn't know. We're as sad as you are. We lost our kid. They're not doing that. They're like screw you guys for even asking.
It's very indignant, and without trying to be too harsh because there's a small community here, it's an interesting strategy.
Get your shit together.
I think being indignant and trying to drag Karen McDonald and this approach, I don't know if that matches the tone of what's going on here or what any juror or circuit court judge is going to feel about this case. I think it's exactly what you just said. If it was me, and I've had media cases, as you know, if it was me in this temperature, in this environment, and listen, I'm a true believer. I'd represent them. So this is, I don't begrudge anyone who would represent them. But in this environment, it's exactly what you just described the Klebold as. I mean, where is the sorrow? Where is in that? Because it's okay. It's okay to be really, really sad, and it's okay to blame yourself a little bit too, and to reflect on what you did wrong. Like all of that's okay. It doesn't make you necessarily criminally guilty. Show it. I mean, that really helps with credibility and bond and just everything to do with this case. And I so far don't get the strategy, but they're playing into the narrative that the prosecutor's been telling, to be honest.